Morning, everyone. Let the record show that we have a quorum present and that we have apologies from Ms. Barbara Connolly, who's down with the flu. So I'll ask the Acting Sergeant Page to bring in Mr. Pandue, please. This morning we're continuing our requirements into the report by the Auditor General on the, fighting the corruption and the legislation we have in place. And our first guest this morning is Mr. Haroon Pandue.
Just read that. Don't give me my name. Should I do name and all that?
No, you're doing it. But go ahead.
Okay. Haroon Pandue, Director of Planning. I swear by Almighty God that the evidence I shall give to this Honorable Legislative Assembly shall be the truth, the whole truth, and nothing but the truth.
Thank you, sir.
Thank you.
Morning, Mr. Haroon Pandue. Thanks for coming. As you will have been informed, we are continuing our public hearings into the state of anti-corruption legislation, etc., in the Cayman Islands. And we invited you because for some time now the Auditor General has been reporting on the conflicts that the public perceived in the makeup of the Central Planning Authority Board, and you will have gotten the references, etc. Can you tell us what kind of progress you have made in terms of getting the members of the board to comply with the recommendations such as register of interest and how you handled declaration of interest by board members? You'll have to ask the witnesses coming next. Standing orders do not allow us to have witnesses in the gallery. It's different if they're both appearing, but you can't sit in the gallery and listen.
Good morning, Mr. Chairman, and good morning to all the members. Thank you for your invitation to appear before the committee today to speak on this report. Mr. Chairman, as it relates to the registers of interest, we have required all board members to file with the department a register of interest, and those registers of interest are then placed on the department's website. We are in the process of updating the various registers of interest for this current year.
How do you handle, how do you determine, or how does a member acknowledge that they have an interest in an item on the agenda?
Thank you for that question, Mr. Chairman. At the beginning of the meeting, through the chairman, we do an initial roll call and ask members to declare if there's any item on the agenda. And just by way of background, as the agenda is also made public in advance of the meeting, and the agenda is also provided to the board members, obviously in advance of the meeting. So at the initial roll call, we ask any member to declare if there's an item on the agenda in which they have an interest in or potential conflict. They declare that conflict. What we recommend to them and what occurs is if there's any potential question, we ask that they declare it. We deal with that as a matter, as a procedural matter, and then as the agenda proceeds, we also ask the members to declare any conflict as it comes up and recuse themselves from the discussion.
Mr. Chris?
Thank you, Mr. Chairman, and I want to thank the director for coming here this morning. Just quickly, can you just, for the listening public, just give us an overview of the planning department, what it does, its role, and just kind of so forth, so at least we can educate the public, because one of the things that we're trying to get out of these sessions also is for the public to understand the role of these departments and what it is that they do, I mean, generally speaking. So while people do have an idea, but just to kind of give them more of a textbook definition kind of thing. Thanks.
Through the chairman to the member, the Department of Planning serves as the administrative arm within the context of the development planning law for the Central Planning Authority and the Development Control Board. Within that remit, the department covers three main areas. So there's the long-range planning of the policy development aspects, which includes the development plan and any amendments to the law, regulations, etc. There's also the administrative arm through the current planning process and processing applications for planning permission. There's also the building control function in which we process applications for permits.
Just quickly, in terms of the national development policy, the development policy, what role does the department play in terms of developing the development plan? Or did I get it right? Yeah, in terms of helping working in the ministry to develop that the national plan.
Through you, Mr. Chairman. The department, through its policy development arm, provides the technical advice to the Central Planning Authority in the development or update of a development plan or area plan. You would currently have heard we're in the process of updating the plan through the Plan Command initiative, and we've currently put out a national planning framework for discussion. So the department plays a largely technical role in collating information, providing policy advice and planning advice, technical advice to the Central Planning Authority, who then ultimately decide the components that make up the plan.
With regards to the current plan that we have, I think it's the 1997 is a development plan that's in use. What do you see as the shortcomings in that plan? That's the reason why we're, I guess, working on a new plan. What was the shortcomings in that one?
Through you, Mr. Chairman, the 1997 plan, I akin it to, it was a plan that met the needs of the day. As the island develops, and obviously as our entire development framework changes, we need to have a plan that keeps up with that framework. A plan that's guided to deliver the quality of life that the residents of the Cayman Islands have decided that they wish to enjoy. And obviously, as a country develops, the definition of quality of life also changes. So I would say that the plan, while it was adequate for the time in which it was put in place, as things, and as with any country, as the situation changes, we need to ensure that we have a plan that obviously takes into account today's current situations, but also lays the groundwork to deal with future situations as they come up.
One of the things that a lot of people had a benefit from in the last time around is that you could have expanded your house by 10% without plan approval. That still exists, or that has not changed?
Through you, Mr. Chairman, what was affectionately known as the 10% rule was repealed a few years ago. As a department, we undertook a technical analysis and we looked at the number of enforcement cases that we were having to process as a result of persons misunderstanding the 10% rule and what the implications were of persons consistently misunderstanding and misapplying the 10% rule. For instance, there was a misunderstanding that the 10% rule would give you the ability to do a one-time addition of no greater than 10% of the current structure. It required you to meet all code requirements as well as meeting setbacks, all the general requirements in terms of site coverage, setbacks. It was restricted to a one-story addition. So we had persons, because they were not fully au fait with the requirements of the law, doing a two-story addition which introduced significant structural challenges. Persons not meeting setbacks. So unfortunately, the situation we found ourselves in is persons would, through this misunderstanding, proceed to develop. We would then come on the tail end, usually by a complaint from a surrounding landowner. We would then have to undertake enforcement proceedings against the landowner, and then the landowner would then be subject to the penalties as provided for in the regulations of 10 times the standard planning fees. Additionally, they would then have to incur significant costs in having to do a number of technical reports. So for instance, on the structural side, they would have to engage an engineer to do a structural assessment of the property, and if there were any deficiencies, also correcting those deficiencies after the fact can prove quite challenging. Or you'd be placed in a situation where individual, unknowns to them, built an addition to their house that literally sat within a foot of a boundary. Technically, that raises an issue in terms of the adjoining neighbor accepting to have that encroachment, and also it added a number of significant technical challenges along the lines of fire ratings. So at the end of that analysis, we found that whilst the 10% rule was there to, again, provide a quick avenue for persons looking to do, development, as traditionally as in Cayman, we would construct over a period of time. What we were finding was that the downside was greatly outweighing the benefit of being able to proceed with the 10% rule. One area as well with the 10% rule that many persons failed to adhere to was that you still were legally required to notify the department that you were undertaking this addition. So all the requirements were fundamentally the same with the exception of the fee. So when you balance out what that fee would have been under the course of a standard planning application, as opposed to what we were consistently seeing individuals being faced with due to these after the fact additions that were not in compliance with the law, as I said, the cost greatly outweighed the benefit.
Thanks very much. And I'm kind of glad you touched on the subject of enforcement, because there's this issue where there's this belief among many in the public where it is as if though the selection of enforcement is basically some people are exempt from it. Because there are many people, and especially some of the bigger developers, where they have done things without planning permission, planning approval, and then they basically seem to get away with it. So I mean, where does a penalty goes in for them? I mean, how is that dealt with? I mean, why do they continue to get away with it?
It's not a perception.
Through you, Mr. Chairman. The law was amended, if memory serves, 2 years ago to facilitate a fundamental change in the enforcement process. Previously, enforcements had to be driven from the Central Planning Authority. So that now has changed, so they're now issued at the departmental level via myself as the Director of Planning. One thing I would say with that is on the enforcement side, there is the option for individuals to apply for planning permission. It does come with the 10% fee, I'm sorry, the 10 times after the fact fee, but there is a process by which, even if we do serve an enforcement notice, the first avenue is to cure that enforcement breaches, they can apply for planning permission. And oftentimes, many persons who have undertaken illegal development do proceed to apply for planning permission and eventually are granted planning permission, which closes the enforcement file. Those who do not apply for planning permission, we then proceed to submit a case file to the Director of Public Prosecution's Office for a ruling as to whether or not there's sufficient grounds to charge. If a determination is made that there is a sufficient grounds to charge, the DPP's office then proceeds with laying charges through the courts. And the process then is dealt with through the courts.
Last year, roughly, how many files did you guys submit to the DPP for prosecution, and roughly how many of them were prosecuted?
Through you, Mr. Chairman, I do apologize to the member. At hand, I have the number of enforcement cases that the department processed last year, which was 248, which I'll also note was the highest number if you look at a 5-year window. I do not have at hand that detail of information, but Mr. Chairman, if I may commit to provide that to the member and the committee in writing at a later date.
That would be fine. But isn't the fee for the 10% addition to the house zero?
Thank you, Mr. Chairman. Yes, sir.
I was just confirming that the government had made that change in regulations without me knowing. Mr. Bush?
Through you, Mr. Chairman, was Dwayne Roberts Airport one of those cases?
Through you, Mr. Chairman, I would ask if the member could further clarify the question for me, please.
That proceeded without planning permission for works.
Through you, Mr. Chairman, the airport did receive planning permission through the development process. There were a number of iterations to the plan, but based on my records, all necessary planning permissions were achieved.
Sorry, did they start with planning permission, or they came back afterwards and got planning permission? The airport, that is.
Without any information to contradict, they achieved planning permission prior to starting.
Austin.
Thank you, Mr. Chairman. Through you, and certainly again, good morning and welcome to the witness. Thank you for being here. There's been much discussion about the relative development boom that is taking place in the Cayman Islands right now. According to the Office of the Auditor General report, the number and value of permissions granted in the Cayman Islands increased significantly in the 5 years from 2013 to 2017. In 2017, the number of planning permissions increased by 40% to 1,156. This can be found on page 28 and 29 of the report. Whilst the value of planning permissions increased by a whopping 180% to 800 million in 2017. So very clearly a development boom and presumably good for the economy. The Central Planning Authority delegates certain powers to the Director of Planning to approve certain permissions known as administrative approvals. We note curiously in the report that the number of administrative approvals decided by the Director of the Planning works out to about 600 a year. That's 51% of the overall planning approvals in 2017, and I wonder if you can explain your role in making these approvals and what is the criteria that must be followed in order to grant those approvals, sir.
Through you, Mr. Chairman, the number of years ago, the Central Planning Authority, with the approval of Cabinet, delegated to the Director of Planning and the Deputy Director of Planning the ability to grant administrative approvals. These relates to houses, duplexes, and subdivisions under 6 lots or less, and 10% additions to commercial buildings, industrial buildings, etc. But nothing that would change the fundamental, sorry, sir, what we would consider to be a material change to the underlying, the initial grant of planning permission. In considering an approval for administrative, the process is fundamentally the same as if an application would go to the Central Planning Authority. So an application is submitted to the Department of Planning. That application is assigned to a planner who's charged with doing a technical assessment of the application. If the application falls within one of those criteria that has been delegated, as I said, to the director or the deputy director for approval, and meets all parameters of the regulations. Again, just to highlight that neither myself nor the deputy, we do not have delegated authority to grant a variance. So for a house or duplex, if it meets all the necessary setbacks, site coverage, building heights, etc., that application then can be considered for administrative approval. The application is processed by a technical planner who's required to complete a detailed checklist, which again verifies that things such as site coverage, minimum lot size, sufficient access to the property, water supply, waste disposal, just to name a few, that those things have been verified to be in accordance with the regulations. The application is then forwarded with a recommendation from the technical planner to either myself or the deputy for consideration. We would then review the checklist and the necessary plans to once again confirm that the application does conform with the regulations and applicable laws. If they do, we then have the ability to sign off on it.
Thank you, Mr. Chairman. Through you, just to follow up. When we talk about some of those applications with variances that, again, go back to the CPA itself to make a decision, it has been certainly shared to me by local architects, whether they be small or medium-sized, or even homeowners who are seeking to expand on their property, that the number of, I guess, complaints by CPA inspectors who come out and say, well, they review the plan, they identify areas that need improvement, they send the architect back to make those corrections. Those corrections are made, they return, resubmit the application, of course, by also resubmitting a fee, and are often told that there are new issues not previously identified in the first inspection that again results that architect or developer to go back to the drawing board and correct those. It has been stipulated to me that this happens quite frequently, and not only does it delay projects, but it increases the costs associated with many of these developments. Can you explain to this committee perhaps why there is this back and forth, and in particular what is being done to address them in the initial inspection so that we can save both time and money?
Through you, Mr. Chairman, to the member, just ask one point of clarification. When you refer, sir, to inspections, so that would be in-field inspections, or perhaps the plan review process that occurs within the office prior to the permit being released?
Through you, Mr. Chairman, thank you very much for that clarification. Actually, both.
Through you, Mr. Chairman, and thank the member for that clarification. If I can address the plan review aspect first. So an application for a permit would be submitted to the department. An initial verification, and this is done electronically, an initial verification is done to ensure that all the components of the application, are submitted at the time. Over the course of many years, looking at our operations and the things that have slowed down the operations, we noticed an increasing trend in applications being submitted that were incomplete. So an application gets to a plans examiner after sitting in a queue, only for them to open the file to say, well, I'm missing X, Y, and Z, I have to reject the app. So we do an initial check of the application to make sure all the necessary documents are contained in the application. It is then submitted to, so I'll take the example of a house. So a house is submitted to the plan review process, and through the years we've strengthened our combination plans examiner and inspector protocols. So previously, if a standard house has 4 major components that are inspected, so structural, plumbing, mechanical, and electrical. In previous years, those were done by 4 separate individuals, which again led to some levels of inconsistencies as well as increased time frames. So the majority of those are now dealt with by one plans examiner, your structural, plumbing, and mechanical, and the electrical done by a separate inspector. So through that process, any code deficiencies, and again, that process is to ensure compliance with the codes. So during that process, the plans are reviewed to, one, determine that they are in compliance with the codes. If they are determined to be in compliance, an approval is granted and it moves to the next step. During that process, if there are any code deficiencies that are identified, those are sent back via our online planning system to the agent, asking them to correct the deficiencies and resubmit the plans. We, over the years, have saw the need, and have been undertaking a series of educational components with the building code to ensure that that we're all operating on the same page, as it were, that what the examiners are looking for, that the architects and various agents are clearly informed as to what those requirements are. And I would say that that has gone a long way to address some of the back and forth. For instance, we've adopted the 2009 International Building Code and International Residential Code. So along with ensuring that we had a code that was robust and met today's safety standards, a large component of that was to make sure that we had a document that was readily available to everyone. Under the 1999 Standard Building Code, one of the deficiencies we identified was simply the fact that not the same information was available to everyone. Because of the age of the document itself, it was not readily available for anyone coming into the industry or even persons who had been in the industry for a number of years. So fundamentally, you had a situation where within the department, we're looking at one set of standards and we could be referencing a code section. So we could say, you must meet section 2108 as it relates to egress windows. However, the individual doing the design work may not necessarily have access to that exact code document to make sure that they're referencing and meeting those standards. So again, through adopting the code and through some various educational components, we've hopefully gone a long way in ensuring that everyone is using the same standards in which to do the designs. Now, as it relates to the question as to the back and forth, because buildings are fundamentally a collection of systems, unfortunately sometimes a change in one area, if you're not cognizant of the impact on another area, leads to a knock-on effect. For instance, separation issues on electrical. When the electrical examiner looks at, and again, this is where we try to ensure that one examiner is taking a holistic view of the project and is not sort of focusing solely on one area and misses the implications down the road. We do have a way to go with that, but we are moving forward in that direction. So back to the example of electrical, an examiner may look at it and determine that the electrical panel, where it's being placed, it creates an encumbrance, something we call working clearance. Now, they may adjust the location of the panel to address that technical aspect, but then they might put the panel too close to, say, a gas appliance, which doesn't come up until someone is looking at the gas plans and layout. So again, this is why we're trying to fully integrate the system. So when someone looks and says, hey, there's an issue with the working clearance on this panel, they can also note the fact that in addressing that issue, please ensure you ensure that the panel does not exceed the required minimum separation from a gas appliance as well. And that's one of the areas that leads to the back and forth that we've found over the years.
Just one, Mr. Chairman, one final. I thank you for those answers, and certainly I thank you for the explanation as it relates to Cayman's building codes, which I don't think anyone would disagree with, are quite robust in this country, and they come as a direct result of your diligence and that of your department. As it relates to code changes, amendments, or updates, or otherwise, is there a central repository whereby all architects, developers, and those involved in the building process can access these specific changes so that they can stay current with various codes, and also so that they can avoid those back and forths? Thank you, sir.
Through you, Mr. Chairman, the codes are produced by the International Code Council, and they're available. They are a copyrighted document. So on the department's website, we do provide copies of any local amendments, and those can also be found within the building code regulations. The actual document itself can be purchased from the International Code Council, and it can be either purchased in hard copy format or in PDF format. And again, that was one of the huge pushes for us to move to a more updated code was, again, so that it was readily available to individuals and that they could then purchase the codes. Initially, when we started the code change process, the department did purchase a number of copies and provided those for sale to persons within the industry. So again, trying to ensure that the information was maximally readily available to all persons.
If I could bring you back to the makeup of the Central Planning Authority, does your department consider that the Public Authorities Law applies to the Central Planning Authority?
Thank you for that question, Mr. Chairman. Legal advice was sought and provided via the ministry, and again, I would ask you may wish to follow up with the chief officer for the ministry that clarified that the Central Planning Authority was not covered by the Public Authorities Bill.
Even with that interpretation, are you aware of, have you gotten any instructions from the ministry that the CPA should at least comply with the spirit of the Public Authorities Law?
Thank you, Mr. Chairman. Yes, sir. So the chief officer has written to the various chairmen for the various boards that fall under the Department of Planning, outlining certain aspects, such as encouraging them to fill out the register of interest and to ensure that those are provided in a timely manner and that those are available for inspection. The ministry has also supported us in endeavors to open meetings to members of the public. For instance, with the Central Planning Authority, those meetings are open to members of the public. Previously, only persons who were invited to appear before the authority were able to attend the meeting. That has now changed, and the meetings are open to the public with the exception of the deliberation and voting component of the meeting.
Is there a particular reason why the deliberations and the voting is prohibited from the public?
Thank you, Mr. Chairman. At this time, the members of the various boards feel that to ensure that there is open and free and frank discussion, that the deliberation and voting components of the meeting are not open to the public.
But that would indicate to me that the so-called open and frank discussions are not necessarily about the application, because if the application is open to the public, the presentation of the objectors is open to the public, the presentation of the person applying is open to the public, why would it be necessary to have the deliberations of the evidence presented to the board? Because certainly I am assuming that the only deliberations that is being done by the CPA is based on the evidence put before it.
Thank you, Mr. Chairman, and your point is taken. What I would say in response is that we continue to work with the board along those lines to encourage the board and provide the necessary mechanisms to help the board to move to the point where all aspects of the matter would be open to the public's viewing.
Because the last time that I found it necessary to go to a CPA meeting, I was not allowed into the public aspect of the CPA until after. I don't know what went on, but until the board, until the CPA decided that yes, we started the meeting so the public can come in now. That is not what I believe is envisaged by the regulations and the need to have these things transparent, because I was very concerned that there were things going on in there that I should know about, but I wasn't being privileged to. And therefore there was a deliberate reason to keep me out. Is that the situation, in that each agenda They are matters that are discussed before the meeting is open to the public.
Thank you, Mr. Chairman. I do recall the specific incident that you spoke about, and I'm happy to say that that prompted a change. So all aspects of the meeting are open, with the exception of the voting and deliberation, as I said earlier. My apologies, sir.
It is the actual act of voting that it is necessary for the public to know if we are going to be able to clearly demonstrate that there are no corruptive practices occurring and that people are not being influenced to make a certain decision. So I trust that in the very near future, the actual decision making will also be a matter for public scrutiny. Another question is, do you have a way of in auditing whether somebody does in fact declare an interest in a matter before the CPA because of their registrar?
Thank you, Mr. Chairman. As I said earlier, the registers of interest are provided to me as Executive Secretary, and they're then uploaded to our website. We have an internal process by which we check those registries, and again, looking at applications to see if there's anything that may readily be apparent, and we will raise those again during that initial stage of the meeting in which we ask persons to declare any conflicts. So that's when those discussions would occur. As it relates to a detailed auditing or verification of the information, no, sir, we don't have a process to do that.
Would that be something that you would consider in the future? Because if we're going to rely solely on the individual declaring an interest, there really would be no purpose of having the registry available.
Thank you, Mr. Chairman. Yes, sir. It is something that we're actively working on and looking at the various international standards as it relates to that. At this time, the focus, because of the state of the legislation, is on education and in providing all the members with the various pieces of legislation that govern their conduct. And also through that education, I guess within a nutshell, making sure that everyone is fully aware of the penalties and the outcomes if they do not comply with those various requirements.
What action could you take, if any, if a board member did not comply with the declaration of interest?
At this point in time, sir, outside of continuing to ask that they provide and seeking the assistance of the chairman and ultimately the ministry, I would be limited as to what action I could take ultimately to enforce that.
Are you consulted by the ministry prior to the appointment of individuals to the CPA? Is your approval for a member of the CPA required before a recommendation is made to Cabinet?
Thank you, Mr. Chairman. There'd be a general consultation, but no, sir, my approval is not required.
So therefore, you have no way, your influence on who is appointed by Cabinet as a member of the CPA is almost non-existent.
Thank you, Mr. Chairman. I would say outside of providing asked to provide a recommendation or flagging any areas of concern, it would be limited to that, sir.
Are you aware of any methodology employed by the ministry in trying to select persons for the CPA, or is that strictly a political decision?
Thank you, Mr. Chairman. I am not aware, and I would ask perhaps, sir, if that question could be directed to Chief Officer responsible for the Ministry of CPI. Thank you, sir.
Do you, you probably won't have this, but can you provide it for the committee? Because we hear a lot about approvals and planning and the value of what has been approved. Would it be possible for you to provide us with what percentage of the 1,156 approvals and $800 million in value actually received a certificate of occupancy? Or is in the process of getting one?
Thank you, Mr. Chairman. Yes, sir, we would be able to do a process by which we can compare what has received planning permission to what has received a permit, and ultimately what has proceeded to a CO. So I would undertake to provide that to the committee in writing, sir.
Thank you. Do you believe that the ministry is providing you with the kind of resources, i.e. in-field inspectors, planning inspectors, to process this kind of 40% increase in applications? How much resources, if any, did you get to deal with that kind of workload increase?
Thank you, Mr. Chairman. Some additional resources were provided within the areas of plan reviews and inspections. As you said, we have experienced a significant growth in the amount of work that is produced by the department. Got some quick stats here. For instance, sir, last year alone, we conducted over 10,000 building inspections. So it is a significant amount of work that is provided. What we are trying to do is to take a multifaceted approach to it. So one, looking to leverage technology to drive efficiencies where we can, looking to use third-party entities. So we've launched the third-party plan reviewer, which can also be increased to cover inspectors as well. Program to, again, engage the private sector to assist us with conducting reviews and inspections, along with some other areas as well.
If I'm doing a building that requires foundation inspection and I don't apply for foundation inspection, the law carries penalties against me as a developer or the contractor. What protections exist in the law for the builder if inspections are not timely? Is there any time frame? For instance, does the law allow, if I apply for a foundation inspection, that it will be done within 24 hours, 48 hours, or I can go ahead and do my work because I have contractual obligations for my client?
Thank you, Mr. Chairman. Within the department's budgetary targets, that is where that information should be listed. So we have a budgetary target to provide inspections within three working days of being requested. Oftentimes, we're able to do them, if not the next day, within 48 hours of being requested.
There are currently no penalties for your not getting inspection done in a time that it depends solely on the resources that you have available.
Yes, sir, Mr. Chairman. There are currently no penalties in law that, in the event that we're not able to conduct an inspection within that time frame.
One of the things that I get that may have influence on the matter that is before us today, that is the corruptive practices, is discretions by the board. It seems that the current legislation allows the board to vary just about anything that exists in the law. Do you believe it is time to either have that discretion curtailed or removed, and it's either you meet the code or you don't meet the code?
Thank you, Mr. Chairman. I would say that, in my view, there would always be instances in which some level of discretion would have to be exercised. But I do agree, sir, that as the industry matures and as a country, we do need to look closely at ensuring that the level of variances and the process by which that is done, we do need to look at that process to look to, one, to streamline it, and one, to ensure that all necessary standards are properly documented in the legislation, that they're readily available to everyone, just to ensure that there is consistency across the board.
You will be available. You will be aware of the development that I have made many representations about the wide use of discrepancy, which eventually led to an amendment to the law that all shoreline properties must now have a certified high water survey within the last 6 months. Because the particular development I'm talking about, the high water mark, was up to my shoulder. The water was shoulder deep. But even with that requirement, as I understand it, the CPA can still vary the setback.
Thank you, Mr. Chairman. Yes, sir. That is an area in which the Central Planning Authority has what we refer to as a variance process, but which they can grant a variance for a seaside setback.
You dealt with the national policy positions. As you intimated earlier, you don't have the kind of input that you would need in terms of the makeup of the CPA to allow you to recommend some kind of balance and act that not every member of the board is in the construction industry or owns a hardware store. You don't have that kind of influence under the current way that the board is appointed.
Thank you, Mr. Chairman. That is correct.
How then does the ministry or the chief officer, who is your direct line of authority, expect to hold you responsible for enforcing register of interest and conflicts of interest on these board members?
Thank you, Mr. Chairman. I would ask perhaps if that question could be directed to the chief officer.
It will be, but right now you are not, there is no memorandum or there are no instructions that you have received from the chief officer or the ministry that would aid you in trying to get compliance with the aspects of the spirit of the Public Authorities Law.
Thank you, Mr. Chairman. Outside of the initial communication I referenced earlier, in which the chief officer wrote to the various chairs of the board, no, sir.
Are you aware of that correspondence containing any punitive action, i.e., if board member B does not submit a register of interest within 90 days, his appointment to the board would be revoked?
I have not, thank you, Mr. Chairman. I have not reviewed the correspondence for quite a while, but from what I remember of the correspondence, there was no punitive actions outlined in the correspondence.
Are you aware of any changes in the appointments to the Central Planning Authority in recent times?
Thank you, Mr. Chairman. Not outside of the standard course in which a member, for one reason or another, resigned their appointment from the board and they are subsequently replaced.
How long has the current chairman of the CPA been in that position?
Thank you, Mr. Chairman. It has been a number of years, but just to ensure that I don't provide the board with an inaccurate time frame, I would ask if I could provide that to the committee in writing.
That's accepted. Can you give us an outline of your department's anti-fraud and anti-corruption processes that you have for your staff, and what portion of that, if any, extends to the board members?
Thank you, Mr. Chairman. The Department of Planning, being a government department, we are covered, we fall under the various policies such as the CIG's anti-fraud policy, whistleblower policy, etc. So as a department, we ensure that we meet those requirements. For instance, all staff members are required to complete a register of interest, which is filed with myself. They're also required to seek approval to have any outside interests, such as a second job, and those are tracked and kept up to date. As it relates to internal operations, through our risk assessment process, we've sought to ensure that our management systems provide sufficient things such as separation of duties. One of the areas, as well as with us instituting our electronic file management and system, is that we're able to offer greater transparency of the process, as well as it has greatly enhanced our document retention, as well as our ability to track better the operations or actions of users. So for instance, with regards to single logons, we can check and to see what actions are taken by a staff member, what time, automatic date stamp, time stamps, etc.
When the CPA turns down an application, which I would assume is based on technical recommendations you have made, would there normally be a requirement of substantial changes to the technical part of the application, whether that's from an engineering point of view, electrical, plumbing, setbacks or whatever, before resubmission to the CPA?
Thank you, Mr. Chairman. Yes, sir. So if the Central Planning Authority ultimately decides to refuse an application, the applicant does have the right to submit a fresh application for consideration. In doing so, again, as a department, we ensure that all the necessary information is presented to the board, i.e. the reasons for the previous refusal, which will also be provided to the applicant, so that the applicant would have to demonstrate how they've addressed those deficiencies that led to the initial refusal.
Or they also have the alternative of making an application to the appeals tribunal if they do not agree with the decision, but that's only on points of law. That's not on, that would not be on design. Only sections where only sections that are covered by law can appeals be made, right?
Thank you, Mr. Chairman. Yes, sir. An appeal can be filed based on the decision of the Central Planning Authority to the Planning Appeals Tribunal, and yes, sir, there are 4 points, which are points of law, that an appeal can be filed on. For instance, that the decision is at variance with the development plan, it's at variance with the laws and regulations, that the board breached the principles of natural justice, or that the board took into account something that it not ought to. And again, just on the point of natural justice, again, for us, that's why it's so critical and important that we enhance the level of transparency of the process, so that all persons are fully informed as to what occurred, so that they can be informed fully.
And it would normally, I assume then, resubmissions would normally be about matters that were not a matter of the law, which would allow you to go straight to the appeals tribunal.
Thank you, Mr. Chairman. Yes, sir. The majority of resubmissions are, again, the applicant seeking to address the identified deficiencies and then resubmit for the board's consideration. And throughout that process, earlier I mentioned the technical review aspect. Ultimately, the decision is the Central Planning Authorities, but when we do that technical review as a department, it is our responsibility as well to flag to an applicant any potential deficiencies where they're not in compliance with the law. So again, that they have an opportunity to address those prior to, or provide the Central Planning Authority with sufficient reason as to why they cannot meet those requirements prior to the application being considered by the board.
So the most recent case that comes to mind for me was the extension of the tunnel on West Bay Road. I note that according to press reports that was not an appeal to the Central Planning Appeals Tribunal. That was a resubmission to the Central Planning Authority. Was there some substantial changes to the design, to the structure, the second time around, which allowed it to be approved, or
Thank you, Mr. Chairman. Yes, sir. That was a new application was filed in response to the refusal. In that new application, in refusing the application, the Central Planning Authority determined that sufficient reason had not been provided to warrant an extension to the tunnel. So in making the new application, the applicant sought to include additional information that was previously not before the board to justify or demonstrate the necessity for increasing the length of the tunnel. And again, sorry, Mr. Chairman, if I may, given the rules under which an appeal is heard, an applicant is not allowed, without the leave of the chair, to add additional information for consideration by the tribunal. So if an applicant decides to have or fail to provide information, or wishes the Central Planning Authority to have new information in which to consider, they would have to file a new application to do that.
I find it curious that you use the term sufficient reason. So there wasn't a legal development and planning requirement that was the reason why it was turned down. It was turned down on the basis of there was not sufficient social, economic, or design. Well, it couldn't be design because that would be structural. Social, economic reasons provided in the first instance, which were provided in the second instance, that allowed the board to approve the application.
That is correct, Mr. Chairman. And if I may, I would add that when we referenced earlier in terms of areas of the law, how we can strengthen the legislation, I believe, yes, sir, that highlights the need to strengthen the legislation so that we're clear as to what those various components are, so that an applicant is clear as to what they need to address and that the board has the necessary information before it.
I don't recall a lot of reasons other than technical why an application could be refused or that are required to substantiate an application, other than things like polling the neighborhood within a small radius, etc., or a matter of, and those that usually require the adjoining landowners to object, as opposed to having the developer have the support of the adjoining landowners. Do you believe that the development and planning law should include those kinds of considerations, or should it be left to the technical code that is applied to buildings, that is contained in international code?
Thank you, Mr. Chairman. I would agree that there is a need for, say, an enhancement in the information that's provided or the rationale that's given in terms of a grant of planning permission, because the technical codes would apply at the permitting stage. So planning permission would have already been granted. In the technical codes, again, you address life safety issues. They address minimum standards to protect the public health and safety, but they do not address the issue as to whether or not a particular type of development is appropriate and what are the potential social economic impacts of that development, or even in impact on the traffic standards, etc. The building codes would not address those areas.
Do you believe that that kind of approval should be handled separately from your department, which should be left then to concentrate on the technical requirements and the building code? Because I see a conflict, or at a very minimum, you being put in a difficult position where something may be approved, but it doesn't meet the law under which that you are administering.
Thank you, Mr. Chairman. I would suggest, sir, that to ensure that that doesn't happen, I think that's why it's critical that the process is fully integrated, so that one of the functions as my role as Director of Planning in advising the board is to flag issues such as this. So to ensure that the board is fully informed that although they may look at a particular development, for instance, and just one that went through the process for a bit, is the definition of a duplex. So the board may take a particular stance that the law may provide them some level of discretion to determine that a project fits within a particular category. But as Director of Planning, I'm there to provide, and my staff, to provide the necessary advice to fundamentally say to the board, where they do have discretion, where they do not, and to ensure that we don't have a situation where something is granted permission under a particular use type, only to get to permitting stage for then, as a department, for us to say, I'm sorry, but yes, I appreciate that you've been granted this permission, however, you do not meet these technical standards. So we ensure that we deliver a fully integrated process to ensure that that level of inconsistency is minimized or does not occur.
Mr. Austin.
Thank you, Mr. Chairman. Through you, certainly I want to thank you for the comprehensive questions as it relates to the anti-corruption controls, and forgive me if this question has been asked before, and if it has, perhaps you can identify that to me. But through you, Mr. Chairman, looking at paragraphs 96 and 97 of the report, which can be found on page 35, it states that since 2007, the Department of Planning has adopted a comprehensive procedure manual that outlines the entire planning process. It defines the core processes for planning permission, provides an overview of the department's structure, functions, and responsibilities. Paragraph 97 states all employees are required to complete a notice of interest each year. My first question, Mr. Chairman, through you is, does this requirement extend also to CPA board members on an annual basis?
Through you, Mr. Chairman, on an annual basis, through my role as Executive Secretary to the Central Planning Authority and the other boards, I work with them to ensure that these registers of interest are provided to us. They were provided last year, and we are in the process of updating them for this year, but there is no legal requirement that they do so.
Thank you. Mr. Chairman, through you, a follow-up. Paragraph 98 states in the second line, the Department of Planning relies on self-declaration by employees of any conflict of interest prior to working on a planning application. We found no evidence that conflict of interest forms were being checked before work is assigned to staff. This creates a risk that employees may be processing planning applications in which they have a conflict of interest. Moreover, as of June 2018, 10 of the 34 staff, or 29%, the notice of interest for 2017 had not been completed. This creates a further risk as notice of interest forms are not being completed in a timely manner. My question through you, Mr. Chairman, is what assurances can you provide this committee and this country that those persons both processing and approving plans do so with the highest levels of integrity?
Through you, Mr. Chairman. First of all, in relation to that, and I thank the member for the question, we have noted the recommendation and we have improved, ensuring that we got full compliance from all staff members for their notice of interest forms, and we are in the process of updating those for this year. As it relates to ensuring that all necessary standards are met, as an organization, we strive to ensure that we have sufficient separation of duties, so that in terms of assignment of work, so staff are assigned work in which they're processed. They're not permitted, how the system is set up, to select what projects they are assigned to work on. And that occurs whether it's an application for planning permission, a plan review to undertake, as well as an inspection. We also ensure that we have certain checks and balances in terms of, for instance, on the inspection side, we don't have project-specific inspectors. So it's a rolling process in terms of who is assigned to a project. Again, we strive to ensure that all our staff are trained to the same level and standard, so that it's not a situation where one particular inspector would be showing up on a particular job site all the time. We also include other inspection mechanisms. So, for instance, prior to achieving a certificate of occupancy, the various inspectors will go out and do their the various disciplines for the inspections, but then there's also, as a final check and balance, that a requirement that a planner also, who's separate from that inspection process, also go out to verify that the building has been built in accordance with the approved drawings, and that sign off is required, as well as with larger projects. Outside agencies are also required to provide inspections, whether it's the Cayman Islands Fire Service, Water Authority, NRA, to their particular area of the construction prior to a certificate of occupancy being issued. And that certificate of occupancy is finally approved by either myself or a deputy director, again, outside of the inspection process, so that along the way we don't have a situation where an individual could potentially conduct a technical review and be fully responsible for signing off on a project.
Through you, Mr. Chairman. Do you have any knowledge of any members of the planning department staff having permission from any of the deputies or yourself or above you to operate any construction-related business?
Thank you. Through you, Mr. Chairman. No, sir. Inherently, because of the inherent conflict, perceived or otherwise, permission would not be granted for such an operation to occur.
Thank you.
Through you, Mr. Chairman, and I want to thank the witness. Thus far, he has been quite informative in terms of the testimony thus far today. With regards to the LPPs, land for public purpose, what is the concept surrounding that whole process? And then more importantly, how is it that, and what is the process in which a developer can, I guess, reclaim or buy back the property that was previously set aside?
Through you, Mr. Chairman, under the development planning regulations, lands for public purpose, the Central Planning Authority, in considering a subdivision of land, can ask for up to 5% of the total area of that subdivision to be set aside as lands for public purpose. That land is set aside either for active or passive recreational purposes for those residents within the development to which it applies. So it's not open to the general public per se. So it'll be persons within the development, as I said, for active and passive recreational uses. One of the areas, and Mr. Chairman, if I may be allowed to elaborate a little bit, one of the areas that we are looking at as part of the development plan review process is making sure that the LPP lands are actually put to a full proper use. As it stands right now, it only has to be allocated, but there is no legal requirement that any further enhancement of that property be done to actually make it viable for, as I said, active or passive recreation. So we've identified that that is an area that needs to be addressed, because obviously as a country, as our development pattern becomes more denser, we believe it's going to be critically important that these areas are actively developed so that persons have access to sufficient open space and recreational spaces.
Thank you very much for that, which goes to my second question. Active and passive use. Now, there is a particular development in my constituent where the NRA has actually taken a portion, or I understand, for basically use of a future road. And it's actually one of the best pieces of property that could actually be used for a park. Now, under what authority? I mean, if the NRA needs something for roads, and that's something that should have been sorted out and not the LPP taken for that?
Through you, Mr. Chairman, I'm not familiar with the exact situation. However, prior to a recent amendment to the law, lands for public purpose designation was allowed to be used for designating for future road corridors. Again, in revisiting the legislation, it was determined that perhaps that was not the best use of lands for public purpose, and again, that there was another mechanism to achieve that. So that was removed as a potential, from the list of potential uses for the property, for LPP lands. So that may have been an older subdivision in which at the time they were allowed to use an LPP designation as a potential future road corridor. But again, that's something that would not be permitted today.
So if the land is designated for future corridor and it hasn't been used, but with the change in the law now, in essence, the residents of that area can, in essence, go and use the property?
Through you, Mr. Chairman, if I fully understand the question, the planning permission that would have been in place at the time would still stand. So if it was designated as LPP for the purpose of a future road corridor, it could be utilized for that, obviously subject to the acquisition process for it. But going forward, that would not be used. That designation would not be used for LPP lands.
Well, I can tell you which one it is to save the any vagueness. Is Little Savannah Gardens, which is still a fairly new subdivision. Now, the LPP that's designated inside there, which would have made a really good park for those residents, for whatever reason, it appears that because it is the LPPs next door to another subdivision, there's this belief about joining all of these roads up together and the whole 9 yards. But at the end of the day now, the people of that community is in essence without a park. And it is a residential area with over 100 homes, no park. And the only use in essence for their LPP now would be for increased traffic through it, which in essence would disrupt a peaceful residential community having more traffic coming from a neighboring subdivision. And I think that is one of the things. So that, well, the question in all of this then is what do the residents will have to do to basically get their LPP back so they can have a park in that area?
Through you, Mr. Chairman, the residents of the area can apply to modify planning permission to remove the designation of that area as a future road, as road reserve.
Okay.
Because that would have been done. Sorry, Mr. Chairman, I didn't mean to.
Yeah, don't continue. Sorry.
That designation would have been solely for planning purposes, as you alluded to. Previously, it was used to ensure connectivity between subdivisions, ensuring that land was set aside for potential future roads. but we have other processes such as the BP process, as well as designating actual future road corridors as a part of the development plan that, in our view, better address the needs for future road infrastructure without encumbering or using the lands for public purpose process, which, as you rightly said, sir, really should be used to enhance individual subdivisions and to provide the residents of those subdivisions with adequate recreational spaces.
Do they send that to you, the letter? Because I guarantee you're getting a letter next week. Is it to be addressed to you or to the Central Planning Authority?
Through you, Mr. Chairman, yes, sir. The letter would be sent to me as Director of Planning. I can then subsequently raise it with the Central Planning Authority.
Okay. The next issue, and this again goes towards development, is the issue of streetlights and speed bumps, like basic stuff within a general subdivision. Now, I have large subdivisions in my area, and a lot of those roads are still in the developer's name. So in essence, the roads are private roads. They're not public roads. From that standpoint, what the residents in those areas require some level of lighting to go in as part of the infrastructure, as part of their safety, security, and everything else. The question in all of this then is there a set amount or a minimum amount of lighting or street lights or that's supposed to go in each of these subdivisions? Because what happens is the people buy the house, and the minute they turn it into their home, they start looking at the other stuff that they weren't looking at before. They just wanted to get their house first. Then after they got it, they're like, wait a minute, where are the speed bumps? You know, where's the lighting? And then they basically turn to the government for assistance in that regard. And I believe at this point, there are certain basic requirements or basic needs that should be met in those overall developments, and then not for it to become, in essence, a problem for the government after they move in.
Through you, Mr. Chairman, a recent amendment that was done to the regulations introduced a infrastructure fee per subdivision lots. It was seeking to address that fundamental issue, and that the planning process governs the creation of the subdivisions in that process, but then it was ensuring that there was a funding mechanism to collect some level of funding that, yes, as you said, sir, that would go towards such things as street lighting, as well as traffic calming measures, etc. So a fee of $100 per lot was introduced under the infrastructure provisions to be able to then be transferred to the National Roads Authority to facilitate its individual program as to providing streetlights. With that, I would say that there is no process currently within the planning process that dictates the provision of streetlights and where they go and those particular standards. And speaking earlier in terms of the need to enhance their standards, I would suggest that that's an area that, again, as part of this overall development plan review process, that needs to be addressed so that we have in place documented standards so that persons would have some level of assurance as to what type of infrastructure that they would be provided, and that we can then use that to ensure that we have adequate funding mechanisms in place to provide that level of infrastructure. Because again, as our urban patterns change and develop and we become more densely populated, as well as we become more fundamentally sophisticated in our development pattern, there are going to be fundamental things that previously had a certain level of discretion to it that I think the consumers, because it goes to quality of life, will expect to be provided. So I think we need to be proactive to ensure we have measures in place to address those needs.
And can you just confirm for me that those funds collected for those infrastructure needs were transferred to the NRA?
Through you, Mr. Chairman, the law provides for the minister with responsibility for finance to be able to allocate the infrastructure proceeds. The latest information that I have is that those funds were to go to the National Roads Authority. Perhaps I could be allowed the opportunity to confirm that and provide that to you in writing.
Fair enough. I'm just putting them on notice if they're listening that are coming for some street lights and some speed bumps.
This is what happens when you allow finance committee every 2 years, is it? Any other questions? Yeah.
Just thanks again to the director. Just one final question from me, sir. And in your opinion, obviously as a person on the ground, is there any laws or legislation that we can change or implement that would actually make your job or your life easier? Because right now, as it stands, there is a perception that only certain people are actually prosecuted by the planning department, and the big fishes keep getting away. And that's one of the things, I mean, because the whole idea behind this report that deals with corruption is that people need to have some level of confidence that the law and everything else is being applied equally across the board. And it creates a situation as if though the smaller homeowners are subject to one rules and the bigger guys have something else. No, and like I said, this is for you to do your job. And ultimately, this is the area in which those things are dealt with in this legislative assembly. Is there anything that we can change or implement or do that will make your job more easier and, in a sense, make the process more effective? Thank you.
Through you, Mr. Chairman, I thank the member for the question and for the opportunity to provide that specific feedback. I would say, sir, that I think it's critical that in looking at the regulations and the law holistically, that we are able to better define the standards by which everyone will be held accountable to ensure that there's consistency across the board, and that it is clear to everyone what constitutes a breach of planning permission, so that again there isn't a level of of discretion or ambiguity in terms of what that breach is. But by clearly defining the standards, we can ensure that that there's consistency across the board and that everyone is held to the same standards, which then would ensure that the enforcement process is clearer to all concerned.
I just want to thank the director publicly again, Mr. Chairman. He's one of the very few as a department that if someone comes to me with an issue, that he actually takes calls or returns calls. He's a consummate professional, and I want to say a great representative to your department and your ministry. And I thank you on behalf of my constituents for the work that you have done and continue to do. Thank you.
Yeah,
Through you, Mr. Chairman, I thank the member and the other members of the committees for those kind words.
Thank you, Mr. Pandoe, and you can duck this question if you want, because it's not intended to be a political question, but it is a question that has eaten away at me for a long time. Do you think that we have progressed beyond the need for a CPA, and that planning approvals should be just left to the technical people and the competence in your department?
Don't answer that. Don't answer that.
In all seriousness, thank you very much for your time, and we appreciate your frankness and your answers, sir. Thank you. It's refreshing.
Thank you, Mr. Chairman, and thank you and to all the other members of the committee, and as well as to the staff of the Auditor General for the great work that they do. Thank you.
We'll take a break, and we'll be back at 1:30 when we will be seeing Mr. Alan Jones, the Chief Officer for the Ministry of Commerce, Planning and Infrastructure. And then at 3:30 we have Mistress Rosa Whitaker Miles, the Chairpersons of the Standards and Public Life Commission Board.